Time can never be your trusted friend or your sworn ally. No, it's the harshest mistress of all. And life is just a chain of moments spent, 1,000 hellos and goodbyes. Maybe a love like ours can lead out its call. Seasons come and pass, one after the last, and along we go. The shift and pull of the tides never sleeps. But if I had a boat and oceans to cross, then I would sail them. Since I have this promise to keep, I will keep you near until the world ends and you are safe with me until the world ends.
Where is your bot now?
I will stay with you until the world ends.
Yes, thank you very much, Cerulean, for the bot. Or whatever your Twitch name is. Good morning, everyone. Welcome, welcome.
Keep you near until the world ends and you are safe with me.
How is everyone this morning? Welcome.
Until
I'm Leonard French, your favorite copyright attorney. But don't worry, I'm not taking the dogs away. They're coming right back. Hello, everyone. Good morning. I'm Leonard French, your favorite copyright attorney. And it's a holiday weekend here in the United States. It's Thanksgiving weekend. So thank you all for joining me on such a relaxing weekend. But it will also be kind of a relaxed, laid-back show. We have a couple very important things to talk about, but we're going to talk about them briefly. And I'm going to pledge to you to get more VODs out this week, more on-demand, edited, produced videos, because mostly the stuff we have to go through is so deep and complicated that it really wouldn't mean anything to try and go through it on a live show. Also, I haven't spent the weekend preparing anything on the 210-page net neutrality rules, nor have I prepared anything on the Verizon versus FCC case that led up to it, nor have I prepared anything on the copyright issues in Australia, where the government has been withholding millions of dollars from artists and journalists while they're using their work. But I did find one story that I wanted to share with you this morning that I did prepare. It turns out that when YouTube sends a notice or posts a notice or takes down a video, the statements that the video is taken down for a copyright strike or a community guidelines strike or a copyright violation, or this Alan Watts thing with Sid Alpha for privacy violations or whatever. When YouTube says that stuff, it is not YouTube making a defamatory statement, at least not according to YouTube. And according to YouTube, there is also a Court of Appeals case that supports them now. So we're going to go through their motion for summary judgment in the Songfi? I'm going to guess it's Songfi case, like Wi-Fi, because if it's Songfi, that would be the Latin, right? I don't know why it would make any sense. So it'd be Songfi, right? So the Songfi case, we're going to go over their motion for summary judgment in the Songfi case. Sound good? So Andrew Watt, thank you. Appreciate it, Tactical. Anyway, so I might talk about that issue as well, but probably in a VOD this week. Like I said, this is going to be a rather laid-back, short, well, not short stream, because you'll see the motion for summary judgment is 33 pages long. We're going to skim through some of that, but much of it is actually really good law on defamation, explaining what the new law is and going into exactly what Songfi has been up to. Not the least of which was some kind of shouting match between the attorneys and parties that apparently bled into the courtroom, and there was some big motion for sanctions, but for some reason the attorneys didn't sign the motion for sanctions, so the judge was like, I can't do anything with an unsigned motion for sanction, and so then nobody ever signed the motion, so the judge just tossed the whole thing. I said his name out loud, therefore privacy violation. Well, come after me on Twitch then. That'll be a little bit different of an experience for him, I guess. Also, like, I know how to go to the court and sue, like, so good luck. Like, I've done it now on my own. Like, I've done it. I went to the courthouse and did it, all me. So I thought the best way to go over the net neutrality stuff would be to go over this short thing that TechCrunch wrote back in April of 2017. They went over a myths versus facts regarding the FCC's net neutrality plans, and then they annotated them. And so this would be just an outright copyright violation if I just showed their website and went over their article. But that's not what I intend to do. I want to go deep into each of these myths and facts and the annotations, and then add my own commentary and have a discussion with you. So hopefully TechCrunch understands that this is for the greater good here. So this is their article, the FCC's Myths versus Facts sheet. Chairman Pai announced his intention to remove net neutrality rules and released a fact sheet back in, I guess, April. Myth, Title II regulations are necessary. This is what the FCC is writing. And then what's in green here is what TechCrunch is adding. So myth, Title II regulations are necessary to provide a free and open internet. Fact, the internet was free and open prior to the FCC adopting Title II regulations in 2015. But then TechCrunch adds that internet providers before 2015 attempted to monitor, modify, block, and throttle internet traffic depending upon the content, user, or application. The internet is free and open post-2015, but with the additional security of these intrusions being illegal, not addressed reactively once discovered, sometimes after years. So this is a major, major point. The internet was not as free and open as anyone makes it sound. The internet, we really hadn't defined many of these regulations. We really hadn't defined many of these, the behaviors. And a lot of the culture of the internet came from the culture of the creators of the internet, which were people like, oh God, I forget all of their names. But there were lots of awesome people who helped create the internet, who all had what is very much the open internet culture about them, and they didn't. Nobody really saw the internet as something to grab and monopolize, and everyone, even including my generation, I'm 37, so even 20 years ago, we were fighting for the internet to be, open and free. And a lot of internet service providers didn't even consider slowing the internet until it became apparent that there were things to slow. Back in '94, when we had dial-up internet, they weren't slowing your internet based on whether you could fit 14.4 down a phone line. That wasn't that the throttling was happening with the technology. The internet backbone was more than able to handle everybody's 14.4 kilobaud connection. So the necessity arose as the internet matured. So it is a misstatement to say that it was unnecessary to regulate the internet before then. It's true that it was unnecessary, but it overlooks why. Things change. People figured things out. Let's talk about BitTorrent real quick. Bram Cohen invented BitTorrent back in 98, I think, 97, 98. And the legislation, or actually litigation, that came from it didn't happen until mid-2000s. And then the slippery slope, the wall of water that was the mass copyright litigation over BitTorrent didn't happen until 2012. So you had 14 years of BitTorrent maturing before people really noticed, before Malcolm Gladwell's tipping point occurred. That's the same thing here. The internet is not something that stays the same. It changes over time. It has a culture. It lives and breathes. I mean, heck, Bitcoin is a thing that many people didn't think was going to go to 8,000, and now all of a sudden it's at 8,000. Things change, and so some of these things need to be regulated or controlled. And if we see that one company like Comcast or Verizon or AT&T is trying to control the entire internet because they own a minority of internet users, end users, connections, then we step in and we create regulations to prevent that. Myth: Title II regulations haven't reduced infrastructure investment and broadband deployment. Fact: among our nation's 12 internet service providers, domestic broadband capital expenditures decreased by $3.6 billion during the first 2 years of the Title II era. Additional fact: one could have said the same thing after the FCC classified cable internet as Title I in 2002. Investment fell then too. The statistics, however, are rather misleading. Many major internet providers have increased spending or projected the decreases mentioned years ahead of time. So what they're saying here is that the coincidence that broadband expenditures or investment decreased by 5.6% after the Title II enactment is merely a coincidence and is not something that happened because of Title II. Now, you could go one step further and you could say that companies like Comcast or Verizon, AT, they have leaders, and those leaders could just decide, hey, I'm going to stop investing by 5.6%, and then I'll be able to say later on, look, we stopped investing. It's a self-fulfilling prophecy. It's not only that, it's more of an intentional tactic if you do it that way. I'm not saying that I know that Verizon and everyone's done it that way, but it sounds like something that they have control over, so you should be skeptical about that. Myth, Title II regulations are good for broadband competition. Fact, Title II is a regulatory framework designed to regulate the Ma Bell telephone monopoly, not to encourage new entrants into the marketplace. And a regulatory framework designed for monopoly will tend to push the marketplace toward a monopoly. What? Are we kidding? A regulatory framework designed to dismantle a monopoly will push the marketplace towards the monopoly. I don't think so. Title II was indeed created a long time ago. Laws are made to last decades or even centuries with the help of judicial interpretation. And in this case, legislative amendment with the 1996 Telecommunication Act. It already applies to many of the companies involved in some fashion. Companies like AT&T, Verizon built their mobile networks under Title II oversight and thrived. So is Title II bad for competition? Well, if you're saying that Title II is bad for competition, then you're completely overlooking all of the smaller organizations that became larger organizations and all of these smaller organizations that can thrive underneath Title II. For example, I am a YouTube creator. So actually, if I'm gonna be that loud, I got to turn myself down. I am a YouTube creator. So what happens? What happens if AT&T or Verizon or Comcast decide that YouTube is not something that they want on their network? It's taking up too much bandwidth. They are going to throttle it. You only get a 360 connection unless you pay for additional bandwidth in a separate fee. So what? How would this foster competition? They would have control of something. They would be able to extract money from it while adding no additional value. You're already paying for a connection based on bandwidth and speed. You already have a cap if you've agreed to that, or maybe you haven't agreed to that, but you might have a cap. Or maybe you have a bandwidth limit, like I have a 200 megabit per second bandwidth limit. My parents have a 6 megabit per second bandwidth limit. But 6 megabits per second is enough to stream Twitch or YouTube. So if you're not using the rest of your bandwidth, you should be able to stream Twitch or YouTube. What if Verizon or AT&T decides that they're going to throttle you because they want to extract more money from YouTube or from the end users? Because that's the other risk here, is it's not going to be just YouTube users or Comcast users that have to pay. It's going to be the companies themselves. Like we saw, Netflix had to pay some kind of fee. It was alleged to be in the millions of dollars to Comcast to stop throttling Netflix connection, even though Netflix was not connected to Comcast directly. The bandwidth was coming through one of Comcast's backbone connections, and so they deliberately limited the backbone connection for Netflix, for nobody else, but just for Netflix. And then Netflix had to pay to get a physical connection. This is the world of VLANs and layer 3 switches and things. We make all the connections we need, and then we program the software to route it the way we want. There is no such thing as Netflix needing its own separate connection from the backbone to Comcast's network with its own cable. Like that's not a thing. You can set that up as like an event, as like for show. You could set it up so that you have to connect a fiber optic cable from one box to another box, but you don't need to do that. It's already connected. You just have to go into the software and unlock the locks that you put in place, because that was something that was arbitrarily done. Myth, Title II regulations are good for privacy. Title II did shift authority for privacy and security from the FTC to the FCC. We did see that. The FCC then put in stronger rules in place to address some internet provider-specific vulnerabilities. Those stronger rules were repealed before taking effect last month. Okay, so yeah, there was a story earlier this year about how Congress voted or something, or FCC repealed privacy rules, so that's already been done. So by giving the FCC the authority under Title II, we only gave the FCC the ability to remove the privacy regulations. Great, guys. Title II regulations are good for innovation. Fact, the Commission's Title II internet regulations have deterred internet service providers from offering new and innovative services to consumers. Additional fact, there is no conceivable innovative new offering that could be brought by an under 1,000 subscriber ISP that would be blocked by an open internet order. I agree. What service are they trying to offer? They're not telling us, the FCC is not telling us which service is being offered that we would like to see. I don't exactly understand what service is being offered that we can't have under Title II that we can have under Section 706 Information Services. By the way, is that what it is? Is it Section 706 Information Services? Yeah, I think that's what it is. The Telecommunication Act. I'd have to find it. I'm not going to find it now. So, next myth. I'm on the wrong browser. Title II regulations are good for free speech and free expression. Absolutely. Fact, government regulation is not the friend of free speech, but an enemy. Their additional fact here is that that's not a fact. That's true. That's a position. Government regulation, the government is not allowed to put prior restraints on free speech. They're not allowed to say what you can't say. The only exceptions for that are for actual safety, health, and stuff like that. So the government can make a law that says you can't yell fire in a crowded building unless there's a fire. That can be a law. I don't know if that is a law, but that can be a law. But they can't say you're not allowed to talk about politics or whatever, or you're not allowed to say bad things about a president or administration or the FCC. They're not allowed to do that. So this has nothing to do with free speech. Title II actually protects free speech by forcing companies, private entities, to observe the utility nature of information as opposed to the, how much cash can we squeeze from the information that we're transmitting. That's the difference. So what do we think of that? Do we have any questions about the article that we went over? Here, we'll go back to the dog music video without the music.
I don't have any questions in my document yet. People, remember you can ask questions in the Twitch chat using the !ask command. Makes it really easy to submit your questions so we can get them asked on stream.
Thank you for the sub, JRW. Thank you for the 5 bits, Salem. People have been asking. I have seen a few asks going through.
No, they have gone to the document. I do have questions here, but none of them were actually about the story.
How about the one about the UN that just came in? That sounds good. Given that the internet is recognized as a human right, could the UN step in anyway? The question here isn't whether it's a human right. That's not what's being attacked. What's being attacked is how we treat it, whether it is a utility, and in the United States, a utility cannot be, a utility has to be kind of hands off. And that's the neutrality part of it. The electric company is not allowed to have separate power lines for people who pay more or something like that. In the internet's case, because it's not a raw power thing where we actually directly utilize the electricity that's flowing, instead we interpret it into information. Because of that, they can manipulate it, and they can decide that some information is prioritized over other information. Net neutrality's Title II provision or Title II designation requires them to treat all information the same, except for some very specific exemptions that are related to technical need, like prioritizing voice traffic over data traffic, things like that. but classifying it as an information service instead is more like classifying it as a newspaper. They can say whatever they want. They can regulate. They can self-regulate however they want. That means Comcast gets to decide what you see. And if you don't want to see what Comcast has to offer, like anybody familiar with the old America Online? It was its own self-contained online service portal thing, but you couldn't leave it. Like, you could open up Internet Explorer and go to the regular internet, but most of the users of America Online sort of stuck to the interface itself. So imagine if Comcast's entire service offering was that. You could have your basic Comcast. Here you go. Here's the innovation that Comcast is being prevented from having. They're prevented from rolling out a $19.99 a month internet service that's heavily laden with advertisements, and they sell it to your mom, but it's not anything but, say, Fox News because they paid the highest bid, and let's say a select basic cable package, so that they can add you to their numbers of basic subscribers. And so you get to have like one news service, one weather service, email, and something or other, and it's $19.99 a month. Sounds great, right? Except that it's now one company controlling the experience of those people. But you can pay more and get the open internet, right? Well, sure, except that they might still be able to do more. What this is akin to is believing that Comcast and Verizon and AT&T are going to be benevolent with their new powers. That is that's what it is, basically. You're giving them. We're about to give them the power to say or do what they want, to get involved, basically, with our internet. They didn't do it before, but they did. They just didn't do it as much. And maybe what they do next won't be as egregious as we are concerned about, but they're going to have the power to do it. That's part of the problem. So
we have plenty of questions now if you want to go through them.
Go for it.
All right, from Ewan M89, do you think that the innovative new services are ways to extort Google, Netflix, Amazon, or end users directly?
It's going to be back-end deals is what you're going to see. It's going to be if Amazon wants its Prime Video to stream over Comcast in a reliable way, then they're going to have to pay up to Comcast. I'm not even making this up. This is literally what they did to Netflix. So now, right now, the problem is that we have built these roadways, we've built these streams, we've built these internet connections. Yes, Comcast helped. Yes, Verizon helped. Yes, AT&T helped, but they got $400 billion from the government. Like, this is public money that was used to build all of this out. These are not private entities that have the right to do what they want with their own membership. This is not the Boy Scouts of America deciding that they don't like gay people. This is Comcast deciding that they have control of your internet, not you, even though you're paying. So you pay for a 100 megabit connection, and even though YouTube is streaming to you only at 4 to 6 megabits, they can still throttle that and claim that you either didn't pay for it or that there's some kind of other need to throttle you. And I feel like I'm fear-mongering here, except that I've been through this. This actually happened. This stuff actually happened. Another story I wanted to tell is not related to net neutrality, but just how shady these companies are. I don't know if you remember Verizon, back when Bluetooth was brand new and Bluetooth just came out, and Bluetooth was the coolest thing that was going to allow you to transfer images and play music. And I don't know if the music part was live back in the first iteration, but definitely was a close range communication service for phones and things. So I went out and I bought a Verizon branded Motorola V551, I think it was. It was a flip phone. I loved the flip. I thought it was the coolest thing to flip out the phone. And I was so looking forward to being able to snap pictures with my phone and then transferring my computer wirelessly via Bluetooth. It was one of the first things I tried to do. Verizon disabled Bluetooth on the phone. It disabled all functionality of Bluetooth except talking to your earpiece. You could not use the built-in Bluetooth functionality to transfer images from your phone to your computer. Why? Because Verizon sold a $50 wired adapter that they wanted you to use instead. That was it. So tell me why that's better for me than requiring Verizon to not screw with the features of the internet, for example. The features basically being that it's featureless, that it is a service, that it is a utility, that it's just a pipe and I decide what flows down the pipe, not you. Tell me how that's good for competition. All that the FCC has done here is reframed these myths and facts as if they are against the company, as if they are against the internet via Comcast. They've chosen not to look at it as something that the end user uses at all. Sorry, what was the question?
Do you think that these innovative new services are ways to extort Google, Netflix, Amazon, or end users directly?
Yes, that's I guess what I was answering.
There you go.
So yes, I think it is a way for them to extort them directly. That's the innovation we're going to see. You're going to see just prices go up and no one's going to be able to do anything about it. Prices, but they're going to couch it. Prices aren't going to go up. You're just going to... There's going to be a new innovative service, Xfinity or whatever, except it's going to be forced on you. And then if you want to opt out of it, it's $20 a month or something like that. I think we already saw this, didn't they? Don't they already have something like that where you can pay your normal fee if you want to share your privacy information with them? But if you want to keep your private information, you have to pay $20 or $30 per month extra. I think we've already seen that once, right? I'm going to skip the copyright in Australia thing. Maybe we'll cover that. We've already been talking for 34 minutes here. We're going to go straight to the YouTube terms of service thing.
No worries.
So this is an interesting case that YouTube, this is a response that YouTube just made. I want to say, 11/21, last week. This is a response in the defamation case that Songfi brought. Songfi sued Google for posting that they had violated the community guidelines or terms of service. This is their motion for summary judgment. This is YouTube's motion for summary judgment to get rid of Songfi's complaint. And if you were paying attention up here, that says 14. That says 2014 there. And it is 2017 now. So this is a 3-plus-year-old case. YouTube and its efforts to combat view count spam. Plaintiffs and the Love Ya video. The Love Ya video is found in violation of YouTube's terms of service. Plaintiffs' response to the relocation of the Love Ya video and procedural history. You should always write your table of contents like this. Your table of contents should tell your readers, exactly what you're about to read. It shouldn't be like chapter 1. That doesn't tell your user anything. Chapter 1, a story. Doesn't tell your user anything either. It needs to say something like, Chapter 2, YouTube did not intentionally or negligently make a false statement. Now you know that you're going to read that in Chapter 2. No third parties imputed a defamatory meaning to the notice. No third parties read the notice as of and concerning plaintiffs. Plaintiffs have no evidence of damages resulting from the notice. There is no evidence that YouTube had knowledge of any economic relationship between plaintiffs and a third party. There is no evidence that YouTube's notice was intended to disrupt plaintiffs' business relationships. There is no evidence that the notice harmed plaintiffs' relationships. So the short version of this, because this is long, the short version of this is that YouTube is arguing that those notices, when they say that you've received a copyright strike or a community guidelines strike or something like that, that is not defamatory. That is not a statement against you saying, yes, you have done this thing. You are guilty of this crime. So the statement of the issues to be decided in this summary judgment motion: does the California Court of Appeals' recent decision in Bartholomew versus YouTube require judgment in favor of YouTube? Can plaintiffs carry their burden of establishing triable issues on their claims for libel per quad and tortious interference? So we're going to go over what libel per quad is. Are plaintiffs entitled to partial summary judgment on YouTube's affirmative defenses or on a fact related to their claim for exemplary damages? We'll go over what that is. Who knows what that is yet? Memorandum of Points and Authorities. Discovery has confirmed that plaintiffs' claims in this case are unsupported and that allegations that allowed them to survive a motion to dismiss are false. On top of that, a directly on-point ruling from the California Court of Appeals has made clear that plaintiffs' claims fail as a matter of law. The court should put a stop to plaintiffs' vexatious litigation efforts and grant summary judgment to YouTube. The principal force behind this venture is Steven Sieber, known as Stephen Marco. He is the force behind an obscure musical venture called Rasta Rock Opera. He is a former building contractor, Sieber, with a long history of litigation, misconduct, according to YouTube. In February 2014, he uploaded a music video called Love Ya to YouTube. Over the next 2 months, YouTube systems determined that an overwhelming number of the viewer requests for the video were spam, playbacks fraudulently designed to inflate the video's view count to make it seem more popular. Something redacted and a further examination by YouTube determined that many of the views actually recorded for the video were also a product of spam. As a result, YouTube concluded that the Love Ya video was in violation of YouTube's TOS. YouTube could have removed the video altogether. It chose a more modest remedy. YouTube moved the Love Ya video to a new location where its inflated view count could be reset. YouTube also posted a brief notice at the video's original location, which read in full, "This video has been removed because its content violated YouTube's terms of service. Sorry about that." Rather than work to promote their video at its new location, Mr. Sieber and his associates have spent the last 3.5 years trying to transform YouTube's routine informational notice into a sprawling federal lawsuit. After the case was transferred from the District of Columbia, where plaintiffs improperly filed it, the court trimmed it down to 2 related causes of action, imposing Rule 11 sanctions on plaintiffs' counsel in the process. With discovery now complete, it is clear that plaintiffs' remaining claims for libel per quad and tortious interference fail for multiple reasons. As an initial matter, this Court of Appeals' very recent decision in Bartholomew via YouTube, November 2nd, 2017, confirms that plaintiffs' whole case is inconsistent with California law. Bartholomew rejected an identical libel claim arising from the exact same statements at issue here, holding as a matter of law that YouTube's notice is not defamatory, whether on its own or in light of the YouTube Community Guidelines tips page. The tip of the Court of Appeal disagreed with this court's prior ruling that had allowed plaintiffs' libel per quad claim to survive a motion to dismiss. This intervening decision categorically defeats not only plaintiffs' claim for defamation, but also their tortious interference claim, which depends on it. The court need go no further than to grant summary judgment to YouTube. So libel per quad. What is libel per quad? Libel, why is this not coming up here? Oh, good. My comment is not showing up on the screen. This is excellent. Why are you not showing up on the screen? Okay, well, screw the comment then. Libel per quad is libel by circumstance. So if someone says to you, that man is a thief, he stole from me, and that's not true, that's slander. If they write it, it's libel. It all falls under the category of defamation. But that is not libel or slander per quad. Libel or slander or defamation per quad is by circumstance. This is a perfect example. YouTube didn't come out and say, you've done something bad. They said the video was removed for a violation of the community guidelines. It's up to others to infer that the community guidelines violation would have to be something bad, would have to be something worth taking action over. So if I'm an advertiser and I see that one of your videos got removed for a community guidelines violation and I remove my advertisements, is YouTube guilty of defamation? And the answer, according to YouTube here, is no. It appears the answer, according to Bartholomew v. YouTube, is also no. But as you'll see in a moment, Bartholomew v. YouTube is not a precedential opinion. Plaintiff's libel per quad claim is wholly unsupported by the evidence. After years of litigation, plaintiffs cannot carry their burden on multiple elements. First, YouTube did not intentionally or negligently make a false statement. We'll go over that. YouTube justifiably believed that its notice was true. The Love Ya video was, in fact, removed because YouTube determined that its content was in violation of the terms of service with regards to view counts, which prohibit artificial view count inflation. Second, no matter how someone might in theory have understood the notice when coupled with the community guidelines, there is no evidence that any third party actually read those two statements as conveying a defamatory accusation, much less one aimed at plaintiffs personally. And that's another important point. Defamation requires actual damage. You can win on one part of defamation but lose on the actual damages part if no one actually took any action based on the statement. Third, discovery has revealed that plaintiffs' allegations about special damages are simply untrue. There is nothing in the record credibly suggesting that any of the plaintiffs suffered a tangible economic injury because of aspersions supposedly conveyed by the YouTube's notice. While the tortious interference claim falls with the predicate libel claim, it also has independently been discredited by discovery. Despite what plaintiffs allege in their complaint, there is not a shred of evidence that YouTube at any relevant time had knowledge of specific business relationships between plaintiffs or any third party. So this is regards to a tortious interference claim. Tortious interference would mean that a third party, in this case YouTube or Google, has done something to interfere with the business relationship of other parties, of two separate parties. In this case, Songfi and Songfi and their business partners or advertising partners. So here it's saying that plaintiffs told elaborate stories about a deal they allegedly had to perform for Nike, about a funding agreement that was supposedly suspended shortly after the notice was published. It is now clear that these were fictions invented by plaintiffs. Finally, plaintiffs' own motion for partial summary judgment is meritless. The court need not address YouTube's affirmative defenses, given that plaintiffs cannot carry their burden of establishing their claims in the first place. Undisputed facts. YouTube and its efforts to combat view count spam. The YouTube service allows users to upload videos that can be viewed by people around the world. The relationship between YouTube and its users is governed by YouTube's TOS. Users accept the TOS. The TOS forbids the use of automated systems. This prohibition is important as view count inflation harms YouTube and its users by undermining the integrity of the service and making certain videos seem more popular than they are. To stop such abuses, YouTube maintains a team that uses tools that are redacted. YouTube deems a video to violate the TOS when its views are found to have been artificially inflated via an automated system. When YouTube finds a TOS violation, whether arising from spam or otherwise, it expressly authorizes YouTube to remove the offending video from the service and or terminate the account. Plaintiffs are various companies associated with Steven Sieber and his musical ventures. Mr. Sieber has repeatedly failed to deliver on his promises to these ventures. Since long before the events of the giving rise to this litigation, Mr. Sieber again and again announced the imminent launch of Songfi, a supposedly revolutionary music platform. Quote, Songfi is a site for all music and goes live December 14th, 2012. Songfi will launch May 11, 2013. Songfi is right around the corner, January 10th, 2014. But none of that ever happened. Even today, Songfi still says revolution begins August 1st, 2017. But there is no functioning service. Mr. Sieber's announcements of an album from the rock opera have similarly fizzled. Since at least 2012, Mr. Sieber has repeatedly announced the imminent release of another album, Respect and Love Manifesto. Those promises continued into early 2014, with Mr. Sieber vowing that the album would be released on February 6th. When that deadline came and went, he shifted the promise to release on November 27th. That album has still not come out. In early 2014, Mr. Sieber created a music video for a Rasta Rock song called Love Ya, Love Ya, Love Ya, one of the tracks on the Respect and Love Manifesto album. On February 14th, plaintiffs uploaded the Love Ya video to YouTube as part of the Rasta Rock Opera channel that Mr. Sieber had created. During the account creation process, plaintiffs accepted the TOS. Love Ya was just one of several music videos posted to the YouTube channel. Others reside there to this day. In April of 2014, 2 months later, YouTube determined that the Love Ya video's view count had been artificially inflated. This was determined based on overwhelming and undisputed evidence. By April 18th, plaintiff's video had a published view count of approximately 23,000 views. Those views were not necessarily legitimate, but the disproportionately high redacted. For one thing, redacted. Another thing, redacted. Response, in YouTube's experiences, these were redacted. Clear indications of artificial viewing activity. Okay, so there was lots of evidence, according to them, that there was artificial viewing activity, and they have some secret things that they use to check that out. Having found clear evidence of a scheme to inflate the video's view count, YouTube exercised its rights and removed it. They posted a notice. Both the notice and the guidelines were general use documents. YouTube posts the same notice for many other instances where it removes videos for view count inflation as well as other violations. This is why the notice does not refer to a specific violation. It is undisputed that at the time that YouTube posted the notice, it knew nothing about plaintiffs, was not aware of any business ventures they were engaged in, and had no intent to disrupt such ventures. The notice's purpose was simply to inform users who might come to the page in a very general way why there was no longer a video. Plaintiff's response: shortly after the video was moved, not removed, it was only moved to reset its view count. Consistent with normal policies, Mr. Sieber used YouTube's appeal process, and a member of YouTube's spam team reviewed the information. That review confirmed the video had been the subject of significant view count spam and had artificially inflated its view count. YouTube informed Mr. Sieber of this decision and invited him to share the video at its new location. Mr. Sieber did not take up YouTube's invitation. Instead, plaintiffs have admitted that they made no effort whatsoever to promote the video after it was relocated, or even to remove the old URL from websites that they controlled. Mr. Sieber responded with a flurry of intemperate communications, culminating in a May 12th letter to Songfi's counsel. That Songfi's counsel sent to Google's chief officer did not identify any actual contracts or business relationships that plaintiff had with third parties, nor did it point to any harm that plaintiffs were experiencing. This letter also included baseless allegations of conspiracy. Three days later, July 25th, 2014, Songfi initialed this lawsuit in the District of Columbia. After the court denied their motion for a TRO and preliminary injunction, they filed the first amended complaint. On October 29th, the judge transferred the case to this court as required by the YouTube's TOS. The TOS say that you have to litigate in Santa Clara County. On June 10th, Judge Conti dismissed plaintiffs' claims for breach of contract with prejudice after finding that YouTube was specifically authorized by the agreement to remove videos that it determines have inflated view counts. On April 18th, 2016, plaintiffs filed their now operative third amended complaint. In response to YouTube's motion to dismiss, the court dismissed the Cartwright Act and fraud claims with prejudice. The court also imposed significant Rule 11 sanctions on plaintiffs' counsel for including a host of baseless factual allegations in the third amended complaint. All that remains now in the case are claims for libel per quad and for tortious interference. We know why when summary judgment is appropriate. No genuine issues of material fact remain. When the evidence viewed in a light most favorable to the non-moving party, that the movement is entitled to prevail as a matter of law. So that what that means, in case you haven't gone over this with us before, is that the moving party is the one filing for summary judgment. They want to win the case early, basically, a little bit early, and the non-moving party is on the defense. So in order to survive summary judgment and the summary judgment movement to win the case, they have to allege such facts and argument that that even when the judge views those facts and argument favorably to the opposing party, that the requesting party is still entitled to win. They're entitled to win not as a matter of fact, not as a matter of circumstance, but by operation of law. There is no other way the case could come out. There's no need to go to trial because the facts are already established, the record is established, the law is established, and the non-moving or opposing party has not successfully opposed the request. So even with the higher standard of having to overcome the light most favorable to the opposing party, you can still win on summary judgment. And so if you do, that's a real win. That's you won on a higher standard than having to go to a trial and winning on the 50-50 standard of preponderance of the evidence. Whereas here the plaintiff bears the burden of proof on an issue at trial, the defendant is entitled to summary judgment by producing evidence negating an essential element of the plaintiff's case, or by showing that the plaintiff lacks sufficient evidence to prove an essential element of its claim. And that's from Celotex and from Nissan, in case you are looking for those cases. Those are very important cases. If you ever have to write a motion for summary judgment, you're going to need to look up the basic background cases like Celotex. YouTube is entitled to summary judgment. Plaintiff's claims fail as a matter of law based on the California Court of Appeals ruling in Bartholomew. Plaintiff's libel per quad claim is based on the theory that the notice is defamatory when read in light of the YouTube community guidelines. While this court allowed that claim to survive a motion to dismiss, plaintiff's defamatory theory has now been definitively rejected as a matter of law by the California Court of Appeals. Bartholomew, brought by the same counsel representing plaintiffs here, involved an identical claim arising from the same notice. As here, the plaintiff in Bartholomew, who had posted a video on YouTube that was removed for view count inflation, alleged that the notice was defamatory. The trial court sustained YouTube's demurrer, holding that the notice was not libelous whether or not it is interpreted in light of the community guideline tips. I forget the exact definition of demurrer, but it's like asking them to dismiss a claim. In a comprehensive decision, the Court of Appeal affirmed that ruling. After a detailed analysis of California law, the court concluded that no claim for libel per se, which is sort of automatic libel, like if I say someone is a thief, that's a libel per se. If you just, all you got to do is say somebody's a thief and you've got defamation. You still have to prove actual damages and all that, but you've definitely got the libel per se claim if someone says something like that in public and you're damaged by it and all that. Libel per quad, though, would require an additional proving of these facts, that somebody read this notice and decided that it was bad and did something against you because they saw YouTube's notice of your alleged violation. Expressly disagreeing with this court's ruling allowing plaintiff's claim to survive a motion to dismiss, Bartholomew held that the notice, whether on its own or combined with the guidelines, was not capable of conveying a defamatory meaning and was not a statement of and concerning the plaintiff. As the court explained, the community guidelines tips cannot reasonably be understood as imputing any particular wrongdoing to Bartholomew. A reasonable reader would have understood that the list on the community guidelines tips page is in fact general, that no one particular offense could be reasonably read to apply to Bartholomew's video. I'm not going to go to the tips page, but I'm assuming it says something like no cursing, no, sexual anything, no violence, no blood, guts, gore, stuff like that. And I'm assuming that his argument entirely rests on that being some kind of defamatory statement, that it could be one of these things. These are our community guidelines, but this is a generic notice. So if you went to YouTube and you saw a generic notice, would you automatically assume that the person in charge of that channel had committed all of those or any of those violations? I don't know. I don't think so. My first skepticism actually is the opposite, to think that they did nothing wrong and that YouTube's just being a dick. In light of Bartholomew, this court should revisit its decision allowing plaintiff's libel per quad claim to proceed. Bartholomew makes clear that plaintiff's defamation claim is not viable under California law. YouTube is entitled to summary judgment. Even apart from the Court of Appeal's decision, plaintiff's claims also fail on the facts. They have no evidence to support the key elements of plaintiff's claim: that YouTube failed to use reasonable care to determine the truth of the notice, that any third party actually understood the notice in a defamatory sense, that any third party independently understood the notice as referring to plaintiffs, that any plaintiff suffered special damages as a result of the notice. Defamation always requires a showing of fault. Under California law, even false statements are actionable only if defendants failed to use reasonable care to determine the truth or falsity. And of course, here YouTube is saying that they use their various means to determine that the view count was inflated. In claiming otherwise, plaintiffs have focused on the word content, arguing that the substance of the Love Ya video was not objectionable. But the issue here is YouTube's state of mind, which is reasonably understood the notice to say. There is no dispute that YouTube believed that view counts are content on YouTube service, and that a video has an artificially inflated view count, which is an example of content that violates the terms of service. No third parties imputed a defamatory meaning. At the pleading stage, the court held that the notice was not defamatory on its face, but allowed plaintiff to proceed on the theory that a hypothetical reader encountering the notice might read the statement in reference to YouTube's community guidelines and could find defamatory meaning. However, at this stage of the case, plaintiffs must do more than speculate about hypotheticals. They must come forward with the actual evidence that some third party, in fact, understood YouTube's statements in a defamatory sense. Plaintiffs must show that someone who saw the notice and also read the guidelines, and having done so concluded that the notice actually carried a specific defamatory meaning. Plaintiffs have no such evidence. The only gesture plaintiffs have made in this direction came in an interrogatory response where they asserted that an unnamed performer and engineer affiliated with the Lohne video were concerned about the impact of the notice. Plaintiffs also contend that over 100,000 people encountered the notice through Facebook and email distribution of the link to the Lohne video. None of this creates a triable issue. To begin, all of the supposed conversations described in the response are inadmissible hearsay, vague reports about what unidentified third parties supposedly felt. It is telling that plaintiffs produced not a single document that supports these assertions. No emails, text messages, or Facebook posts. Plaintiffs' uncorroborated, self-serving hearsay cannot serve? Wow. Let's start that sentence over. Plaintiffs' uncorroborated, self-serving hearsay cannot save their claim. We know for a fact that several of these people did not understand the notice that way. A producer for Rasta Rock Opera thought that the notice was a vague message. A proprietor of an establishment where plaintiffs claim the opera was performed testified he was confused, but he never believed anything was wrong with the substance of the video. Mr. Sieber's somebody or other, Derek Sieber, I can't tell if that's a son or whatever, never read YouTube's community guidelines. The most he could say was the notice was vague. In short, various people are confused or concerned about a vague statement, and that's simply not enough to sustain a libel per quad claim. And so YouTube goes on for some time here that I think we don't need to continue to go over and repeat over and over and over. But you understand that lawyers have to make their points, right? And so they get down here and I think they ask for complete summary judgment. For these reasons, summary judgment should be granted in favor of YouTube, and plaintiff's motion for partial summary judgment should be denied. Is there like a conclusion? Plaintiff's motion for summary judgment, that their second motion in such case, their second motion. Plaintiffs do not seek summary judgment on either of the remaining causes of action. Instead, they focus on YouTube's affirmative defenses. Okay, well, affirmative defenses are another defense part that the defendant would do. Affirmative defenses are basically saying, if we're guilty, here's why, or if we committed the acts that are complained of, here's why we're not guilty of a legal offense. And that's something that can be attacked on summary judgment. It's kind of weird that that's what would be attacked here. Usually you attack affirmative defenses with a motion to strike. So very interesting there. Very, very educational, right? What do you think? Should YouTube be let off the hook of this defamation action, or do you think the plaintiff is right? Do you think that the plaintiff really was hurt by a notice that the terms of service violation was the reason that the video was taken down? And the question isn't were they hurt as in was their video taken down. The question is were they hurt specifically within the elements of defamation. Was there a false statement? Did someone perceive that false statement, for its full value according to plaintiff? And did they take some kind of action that damaged the plaintiff? And so it looks like not any of that happened here, at least not according to Google. But Songfi's owner, Mr. Sieber, could certainly have a different opinion. But this seemed like a good summary of whatever is going on in this case. So what do you think of that? I also realized that I skipped a bunch of your questions. I went straight into the second story.
We have
and
questions.
Skipped a bunch of your questions from the first story. So yeah, how about we answer your questions for the rest of the stream here?
Sure. First of all, we have a new meme has been born in the Leonard French chat. If you can, if you can direct your attention to the chat for a moment.
I've noticed there's a bunch of redacted white text.
Yeah. We are redacting text now. That is a meme in your chat now. So
I don't even know how to do that. Like, how do you just type
Oh,
white blocks?
they're just characters. It's a character that you can use. There's like black solid characters.
Okay. Cool.
So yeah, that's a thing. Question number 1. It's from Lost Patrol. Unfortunately, it appears to have been redacted. So, unfortunately, I'm not going to be able to ask that question. They literally just submitted redacted as a question.
Nice.
Question from blah, 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 blah. How did they get this many things redacted? Is that something they can ask the judge to do? And if so, can the counterparty read the original text, or is it only limited to the court?
I am going to assume that there was some kind of agreement between the parties to redact and protect this stuff. When lawyers file things in court, there are redaction rules that are already published. In fact, you have to check a checkbox that says that you've read them every time you log in. And the redaction rules are for things like social security numbers, certain medical information, and things like that. There's also something that you can do by agreement of the parties. You can redact things by agreement of the parties, and you can also ask the judge for a protective order, and that protective order is usually something the judge grants, and it allows you to mark things as confidential. Otherwise, most things are public. So yes, the judge would get an unredacted copy. The opposing party would get an unredacted copy. The opposing party would be forbidden from releasing an unredacted copy to the public. And everybody else gets the redacted copy.
Fair enough. A question from Sweet Orange Bunny. What are Rule 11 sanctions?
So Rule 11 is the federal rule of civil procedure, and there are various other similar rules in state or local procedure. But Rule 11 is the one that gets cited because it's easy to understand. It says that if you sign a pleading, and you have to sign your pleadings, you have to sign your papers and documents and things, that by signing it, you are making a statement. Not just the statements in the document, but also a statement that you have done your due diligence and that the statements and arguments and claims that you're making in the document are supported by facts and evidence, that you have done your due diligence, that you believe that these are meritorious things, that they are not submitted for an improper purpose, they are not frivolous, they are not intended to cause delay, they are not intended to just litigate as opposed to actually move towards trial. So by signing your papers, you are subject to Rule 11 sanctions, which is to say when you violate Rule 11, someone comes to court, or a judge can do it on their own, but most of the time the opposing party has to come to court and argue those Rule 11 sanctions. They have to submit a motion for Rule 11 sanctions. They have to support that motion with argument and evidence of your violation or of the violation. And then the judge will hold a hearing and determine if the violation is egregious enough to warrant actual sanctions. What are sanctions? Well, that's anything that you can think of that is a corrective or punishing action, something that deters the future misconduct, or something that corrects or punishes past misconduct. So Rule 11 sanctions are usually money damages, but it can also be worse. It can be like either an intentional interpretation of your case. So maybe the sanctions for not responding to certain requests for evidence, or the sanctions for filing something improperly with regards to evidence, are that the evidence gets used against you. Instead of being seen as favorable to you, maybe the evidence now gets seen as against you. It's very circumstantial. It's something the judge will tailor to each and every individual case. In this case, I don't know what the sanctions were. I'm guessing they were money damages for all the frivolous filings. I'll look it up real quick here. Next question.
Question, a real question from Lost Patrol. Does libel per se apply to media that reprints allegations from another person, such as the Harvey Weinstein case where people make accusations against him and those allegations are picked up by major media?
The first part, one more time.
Does libel per se apply to media that reprints allegations from another person?
Yes, it does, but it applies a little bit differently. If I understand correctly, the reproduction of those facts can be defamation if the media organization is or becomes aware, if you notify them that the facts are not that way, they must issue a retraction or correction if they agree that the facts are probably not that way. And that gets some people fired up because the retraction is often not nearly as popular as the original article. So you might get 200 million or 200,000 views on an original article, and then the retraction might get 15,000. So you might still have a whole bunch of people out there who think that somebody did something real bad, and then turns out that they didn't. So, and then you might have a hearing. You might have a court case. The person who was allegedly defamed might take that media outlet to court, and the court might have to determine whether they took it down fast enough, whether the retraction was good enough. So that's what media organizations are dealing with.
Question from Memhav. What would the penalty be if one of the parties released an uncensored document?
It would be sanctions. It would be contempt of court, contempt of the protective order that led to the violation, and that would be, the judge would either issue a fine or jail time or something.
All right, I have a couple of questions left over from the last case, if you don't mind going over those.
Yeah, I'm looking. Go slow though. I'm looking for this sanctions thing.
Oh, fair enough. Minotaur 199 asks, will it affect the EU if the FCC removes this net neutrality and gets its way?
Probably not. Why? The net neutrality regulations. Have you ever heard of Level 3 communications? Have you ever heard of MSI WorldCom? Have you ever heard of UUNet? Yeah, you really don't hear about internet backbone providers. They don't usually get involved in crap like that. They're usually pretty good about not doing shit with your internet connection. It's Comcast, it's Verizon, it's AT&T, it's the end user providers who try to mess with stuff. So if you're in the EU, you don't have Comcast, you don't have AT&T, you don't have Verizon. So what the problem would be is if you were a provider, like a creator or a broadcaster, or even like a game developer maybe, someone who provides media, especially streaming or data-heavy media, that goes to end users in a Comcast region or Verizon region or AT&T region or whatever. You may find that YouTube is slow or Netflix is slow, or let's say you are Hulu. You might find that Hulu is slow on Comcast servers or Comcast services. And so you might call Comcast and say, hey guys, what's up? We're getting a lot of user reports that they can't even run a 3 megabit stream on Comcast's system. And Comcast goes, oh, well, I don't know what's up. You might have to pay us to look into it. And that this is what happens. And then Hulu is suddenly doing, some bidding of Comcast for some backroom deal. Now, maybe Hulu can say, well, fine, we're going to tell the world about your unscrupulous behavior. And Comcast goes, oh, no, that's okay. We'll keep the price nice and low. It'll only be $500,000 this time. And in return, you have to sign a confidentiality agreement. It's exactly what they did to Netflix. We don't know what the amount that they charged Netflix was because they made Netflix sign a confidentiality agreement. What if Netflix didn't sign the confidentiality agreement? Well, then I guess the price would go up a lot, or the problem would just continue. It was obviously done under duress on Netflix's part, and Netflix has said so since then. And you can go look for the articles and see how much Comcast gloats that they were able to extort money out of Netflix this way. It really reads like an abusive spouse. It really reads like a domestic violence situation where one spouse is more powerful than the other, so they literally just physically extort whatever they want out of them, and the other spouse doesn't know to leave. It's really that disgusting. Let me see what I can find about this order on motions for sanctions. Denying motions for sanctions. Hang on. Let's see what the motion for sanctions looks like. Boom. Plaintiffs Song Fi Inc. and Rasta Rock move for sanctions against defense counsel. Defendants have filed a response. Moving plaintiffs have not filed a reply. The time to do so has passed. Having considered the papers submitted by the parties, the court denies. Oh, this is the one. So Song Fi moved for sanctions against Google and then never signed, even after they were told it was unsigned. You may remember that Alex didn't sign something and the court gave her a chance to sign it, and I wasn't allowed to undo that. So this is the same thing. They were given a chance to sign and they decided not to sign, and so they were denied their motion for sanctions. That's what happened. That is what happened. Next question.
Currently, the last question I have, you guys can ask more using the chat, from CasperVid. Would you support the separation of law between content providers and network providers? So, for example, in the Netherlands, we separate power generation companies and the electricity network. They're not allowed to be affiliated with each other.
Yeah, so that's what Title II is sort of trying to accomplish, is saying that the provider is at least subject to some fairness and neutrality rules. I would actually like to see it go further. Right now, there's problems with accessing the same telephone poles, and oftentimes, in order to comply with safety regulations, certain non-electricity, certain non-power lines must be moved, like cable lines, telephone lines, things, just like a few inches or a few feet up the pole. We're not talking about like cutting them or anything, just like moving them up the pole. And right now, that's the Comcast or service providers are allowed to stop other providers from coming in and using the same telephone poles. So how did we fix that problem with electricity? Because obviously we don't have 60,000 electrical lines up there for one for each provider of electricity. Instead, they all share the same network. This is how it really should work. And I'm not talking about from a communist or a political standpoint. I mean from a technological standpoint. We have so much bandwidth on a fiber optic line. We really just should have one fiber optic cable to each home. It all goes to a central software-controlled switching system. And that software switching system is an open, compliant system, locked down, but I mean open in the protocol sense. And then Comcast comes in and sets a setting on that says port 1 going to Sue Mary's house is, or Mary Sue's house is, of course it's Sue Mary, right? Because I'm a lawyer, so it's Sue Mary. Going to Mary Sue's house, that port belongs to Comcast. Port 2 belongs to RCN. Port 3 belongs to Time Warner. And, then each provider gets locked to their customer. What we should not be doing is having these fights are all money. These fights are all just delaying and money. And why are we doing this to ourselves? Japan has this amazing gigabit network that is very inexpensive. Why do we need to let media companies come in and try to exploit the method by which that media is delivered? It's fine that they are media distribution companies, but they shouldn't be controlling both the connection to the internet and then deciding what media is prioritized over top of it for anything other than absolute technological need, like, for instance, prioritizing voice over IP traffic or something like that. So you can say all you want that you don't want your ISPs to be government run, but the government's not running them. The government's just saying that the method they operate by has to be fair. That's all. Do we have any other questions, Brandon?
Oh, we have a few general questions.
Go for it.
Myarbar asked right at the beginning of the stream, is Twitch now going to be home of the Sunday live stream?
For the foreseeable future, Twitch will be the home of the Sunday live stream, and any stories that I feel are good enough to break out as separate VODs will be posted to YouTube, will be posted privately to YouTube while YouTube does its stupid demonetization thing and then remonetization thing, and then they'll be posted on YouTube. And this is what we're going to do from here on out to simplify things, because I'm getting some feedback. I'm getting a lot of positive feedback. A lot of people seem to like the show. Wherever I go, you follow. On YouTube, I get a lot of viewers on the live streams, but I also lose subs. And I also get a lot of complaints that there are too many notifications and that people are unbelling me or unsubscribing. So I wanted to look into simul streaming on Twitch and YouTube. Well, it doesn't solve the problem of people receiving too many notifications on YouTube. And Twitch has this stupid exclusivity agreement that says that I can't stream to two places at once. So we'll stream live to Twitch. I'll stream gaming to Twitch, and I'll stream the show to Twitch. And then I'm recording this, so I'm not just recording the stream, I'm recording my actual, like, my end of it. And I will break out what I feel are decent videos for VODs, which will get posted to YouTube. In addition, I will be also creating a number of regular VODs that I normally have pledged to create, like the Milwaukee versus Snap-on tool battery thing, like Verizon versus FCC, like the new broadcast media ownership things, and like the information service versus Title II net neutrality video, for example. I'll produce those separately offline. I'm getting better at this, where our workflow is increasing. This camera is working beautifully, and it takes, like, the camera literally helps it take less time to produce as well. And we'll go from there. If I have to adjust, I'll adjust. If we have to go back to YouTube, we'll go back to YouTube. Who knows what will happen? I'm working on all sorts of things in the background and trying to change as little as possible while making everyone's lives better and the content better. So I need your feedback sometimes. Excuse me. I need your feedback on, like, am I producing too much content, too little content? Do you want to see a wider variety of content? Do you want to see a more narrow variety of content focused specifically on copyright or YouTube or something like that? I know that I've had videos like the H3H3 lawsuit that got hundreds of thousands of views. I'm not trying to make every video a 100,000 view video, but it would be nice to find out what my audience really enjoys. Now, it's also the holiday season, and there are 306 of you here when we normally draw, like, we drew 600 last week, and we normally draw about 2,000 on YouTube. But this is also concurrent viewers, and it doesn't mean that there's not, 1,000 people who have stopped by. Stick to my expertise like now. Okay, that's definitely a, that's definitely a thing. I definitely don't want to go too far outside of my expertise. Some people have said that I have been getting political. I have been trying to stay away from political, but it's kind of impossible not to talk to about political stuff in a weird political climate like we have now, and especially when so much of the FCC stuff and everything is touching our core competency. But what I'm not going to do is espouse, Republican or Democratic views that you have to go vote one way or another. If anything, the most political views I'll espouse are rather philosophical views, that I do believe that humanity is something more than blindly capitalistic, while also not discounting capitalism's virtue as incentivizing progress and incentivizing innovation and incentivizing selling and creating and making and doing. So there's good and bad to everything. That doesn't mean that I'm trying to get political about it. So I apologize if anyone felt like I've been getting political, but I have been trying so very hard not to be political while still talking about things. But see, I'm trying to avoid the drama of the political stuff. And if we talk about political stuff, it'll be like the Manafort and Gates indictment. We'll be reading the document. And so, as opposed to me commenting on what I think about Trump or anything like that, we'll talk about the indictment. But again, we're only going to talk about that stuff when it comes up. Other questions?
I have a question from Captain Yasho.
Okay.
Where's the Twitch overlay?
I turned the Twitch overlay off. My bad. When I was doing a bunch of... Oh, that's Twitch chat. I think I turned the overlay off, like completely off, yeah.
Oh, you'll have to get a
I have to
new link.
re-add it.
Oh, shoot, okay.
Well, I was having some CPU issues. It's happening again. We're up to 40% CPU here. I don't know why.
Huh. All right. Do you not want the overlay link?
Yeah, sure. Let's try the overlay link.
I believe that's correct.
Yeah, I think you gave it to me last time.
No, hold on. That's not correct. I'm sorry. That's the wrong link.
Okay.
That is the correct link. Sorry, guys. Just doing a little... I probably should have mentioned it earlier. I just didn't notice until just now. So... we did have a question from somebody. They noticed that in the last... Oh, I see. Why is that happening? I'll fix that later. Sorry about that. Somebody...
Oh, I'm not worried about it.
Yeah.
It works.
Somebody asked, in the last week's VODs that you uploaded, you didn't put live in the corner. And that makes it a lot easier for people who did watch the live stream to kind of avoid those videos.
The title said it was the live stream.
Yeah. I think people look at thumbnails more than titles, honestly. Like,
wow. Okay. Well, either way, I don't know that I'm uploading this VOD, live stream VOD. Well, I guess we can upload the VOD directly to YouTube. I'm still going to let it demonetize and remonetize. Excuse me. But I will leave the VOD up on Twitch, so anyone who wants to rewatch the VOD if you missed it or whatever, you want to check something out or clip something that you saw, it will be up on Twitch. I'm not withholding it from Twitch. I'm just trying things. If this turns out to be a terrible idea, I will change things. We want the community to enjoy the channel. That's the primary thing. It's not here to make money, although I do need to make a certain base amount of money to live, and I have stopped practicing the enormous amount of traffic cases that I was practicing. So while I'm not asking you for more money, we do need to keep the system working the way it is. So I'll be making small adjustments, and I hope that you'll be patient with me as well.
but that's basically all I have for you on my end.
Okay.
Ooh, that doesn't look great.
We'll do the musical outro. Scython, I have fewer clients. I literally finished all of my client matters, and I have 3 or 4 matters now. I think I have to remember that I have my last traffic case this week, and not, like, forget and not go to it. When is that? Yes, I have a traffic case. My last remaining traffic case is on Wednesday. Then I have a continuing education thing on Thursday. But, like, everything else is me working on the Imagos case, 1 or 2 divorces that I have left, and 1 or 2, like, non-litigation representation things that I have left. I did see that there was something with Harmony Gold. I have not seen what it is yet. Night to call. Oh, thank you, Jedi Private Eye. I know who you are. Also, look for an update in the Alex Mauer case this week. If everything goes according to plan, I should have a fairly major update fairly soon. I cannot say a word more, so do not ask. Ooh, my Google Calendar will get an upgrade. Yay! It works. Okay, cool. Google Calendar upgrade is nice. Oh! Martinis are okay, handguns are okay, I'm still waiting on the sexy woman. One day. I'm holding out for the right person. Was that bothering you, Captain?
Yeah, it really was.
Did the Islands of Nine people ever
They are
bring the server up?
apparently furiously working to get that server up. So,
Yeah, that's the latest announcement is still from last night that they're still working on it.
Yep. So I'm hoping that comes soon because we do have keys for that. We can play that.
Yeah, I was looking forward to playing that on stream.
Islands of Nine, if nobody knows, is it's another battle royale kind of futuristic first-person game, and we got given keys to it from the developers, but servers haven't been up since we received the keys, so they were gonna go live yesterday and they didn't, and now we're eagerly waiting for them to go live. So
yeah. Babular, where is a good place to go shooting now? Shimersville closed. There's a new one on 145, just up from the mall. It was the firing line. It closed for a number of years, and now it's back open again. I heard there's a place in Emmaus, and of course I go to Heritage Guild and Easton Fish and Game out in Easton. Dreamer done. Yeah, I figured that out. I don't know. Often it's difficult to figure out what setting to put Captain at so that he doesn't get drowned out, or at the same time, blow everybody's ears out of the water.
I have nothing to do with that.
There is, Kate. There is a Hughes v. Benjamin update. We're going to go over that this week as well. Apparently, Sargon is saying he was not served properly, which is what I suspected he was going to say. And so I think the letter is asking for a hearing to figure out how they would like to handle that. Yes, Jedi Private Eye, divorce cases are super stressful. Your clients are often never happy with you, even when you're doing things properly. Nothing could ever be done fast enough. They want it to be over right away, and to find a divorce client that is patient and kind and paying on time is a rare thing. Read what? Anyway, so thank you all for joining me. I am Leonard French, your favorite copyright attorney. And that has been our stream for Sunday, November 26th. We do have a Discord channel. Captain has put a link to that in the description. Wait, in the chat.
Actually,
And if you would like to join us,
that's Cerulean's wonderful bot doing it automatically at a perfect time.
oh, cool. Thank you for yeah, I happen to understand now why divorce attorneys charge so much money. It's not because the work is hard. Like, the actual legal work is actually very easy. It's basically the butthurt tax, or the asshole tax. It's, I'm going to be dealing with you at the worst time of your life, and you're going to get upset, and so I need to be able to remind myself when you're yelling at me that I'm getting paid for this. That's what that is. So definitely some gaming tactical. I have a couple different games that we're playing. Cold Waters is the one, and of course there's PUBG, and we got, the stream working a little bit better, so PUBG streaming should be great. Captain, I imagine you're going to bed, so you're not going to be joining me for any PUBG?
How did you know?
Because you were up all night.
Should probably stop doing that.
Yeah, give me a few minutes, guys, and I'll come back with a stream of some kind of game. Okay? All right. Love you guys. Have a great week. I'll see you in several videos this week, I think, because I'm going to be working on them. There's so much to talk about net neutrality that I can't wait until December 18th, right? I gotta really get this going now before it even gets any closer. So, love you guys. Thanks for joining me, and I will see you in my next stream or video or whatever. I'm Leonard French, your favorite copyright attorney. Oh, and thank you to all of my sponsors. AVE has sponsored the videos. You know that I've got my $5 plus supporters scrolling on the LED panel behind me. And I just forgot to name my my $50 plus supporters: John Steele, Westin, Lohne, Nate, Beck, Lydia, Collinson, and Gavin Barnard for the month of November. Thank you very much for all of your... No, the gaming channel is this channel. If you follow this channel, my gaming will show up on this Twitch channel. What I don't do is I do not stream my gaming to YouTube. The YouTube channel is pretty much completely separate and is only law stuff, whereas this is my more general gaming channel. I do have a personal channel on YouTube, and I do have a dogs channel on YouTube called Such Dogs. Let's throw that link up there.
Sure thing.
Anyone who hasn't left yet and would like to subscribe to this channel, this is the channel where I post dog stuff. And let's see, what was the last thing I posted? Yeah, something about 4 days ago. So the dog stuff goes up pretty regularly whenever I get a chance to post it. This background footage that you see here will get edited into something that will go on to the dogs channel, the Such Dogs channel. And why do we call it Such Dogs? Well, there are wonderful dogs, there are beautiful dogs, there are obedient dogs, there are cuddling dogs, there are lovely dogs, there are friendly dogs. These are such dogs. So that's my pitch for that. Anyway. So, love you all. Thanks for joining me. I will see you in my next video, and thanks for joining me. Love you all. Bye.